Hello, friends and clients of Walker Gates Bella. I am Jennifer Walker Gates, immigration attorney, and I am here today with my fellow attorney, Diego Nuñez. Hey, Diego.
Hey, Jennifer.
So we were going to talk today about the permanent bar. The permanent bar is something that I personally hate. It comes up a lot when we are meeting with potential clients and immigrants and their families. And so I wanted to give a little overview of what it is and how it works and what it means, and just kind of explain it because it's so confusing. It's really actually hard for some people to believe that the way that it functions. It's hard for me to honestly believe the way it functions sometimes. So but before we do that, before we get into the permanent bar, I would like viewers, please hit subscribe to our channel. We are going to be publishing lots of good videos this year, every week, an update, an informative video to help make sure that all immigrants out there have access to high quality, reliable, trustworthy information about the immigration process and how it works. So please hit the subscribe button. And then I'm going to ask you, Diego, can you just kind of give us a general overview of what is the permanent bar and like when does it come up? When do you typically, when does it tend to enter the conversation that you're having with immigrants about their cases?
Right. So so the permanent bar is kind of a confusing and complicated subject to talk to clients, but it's something that they have to understand because it helps them realize what options they do have or not. And the permanent bar comes up under several different scenarios. So one can be through an expedited removal order. So that when you get a deportation order from an immigration officer at the border. The other one can be when you get a deportation from an immigration judge. And the other one is through unlawful presence. And I'll explain a little bit about unlawful presence. And that's probably the topic that we talk about the most with our clients. So if you have a deportation order, you have been deported from the United States. If you attempt or do enter the United States without inspection, without lawful inspection, then you trigger what's called a permanent bar. And it's not technically permanent because if you stay outside the United States for 10 years, you can apply for forgiveness and re-entry permission to re-enter the United States if you have a visa available. Now, unlawful presence is a little bit tricky because it often relies on a client's memory about the times that they've spent in the United States. And unlawful presence is something that started on April 1st, 1997. And at that time, a law was triggered that started counting the time that an individual is present in the United States without status. So let's say I enter with a visa, but I overstay my visa. And so then at the first day after my document expires, I start accumulating unlawful presence. And if I get a year or more of unlawful presence, and I leave the United States, at that moment, I get a 10-year bar. Okay. And so often I explain it to clients, it's like getting a yellow card in soccer. All right, so I've been warned, there's a warning, I'm not completely out of the game, but in order to come back to the United States without a problem, I have to ask for forgiveness through a waiver process and I have to enter with a visa. Okay, but what happens if I decide, well, you know what, I don't want to do that, I'm going to just come in illegally? Well, so I explain to clients, well, then that's when you get the red card. That's when you're out of the game. And so it doesn't matter if you have a US citizen wife or a US citizen children that are 21 or older, or you have the greatest boss in the world that wants to help you get status. their petitions for you are not going to help you get your status until you're forgiven for that permanent bar. And often, what we see, especially living in Texas, is immigrants that got used to coming and going from here to Mexico and back, not realizing that this law in 97 was going to have these severe negative effects. And so now we were on year 25 of this law, and it's prevented, it's got to be in the millions of, for people to be able to get their status.
That's right. And so I think, just to give a quick recap, what you're saying is an expedited removal, which is one of those situations that happens at the border with an officer, where maybe somebody's coming in with, like, they're trying to use a fake birth certificate or some other fake document to come in at the border, and a border officer catches them coming in lying, committing fraud. Usually people who just enter without permission don't get expedited removals from the border, but some have. But anybody who gets an expedited removal, it's like a little mini deportation, and they'll usually tell you you can't come back for 5 years. But then if you do come back without permission, if you sneak across after having that, then you trigger the permanent bar, which, again, as Diego said, doesn't mean permanent. It means you don't get a waiver until you've been outside the United States for 10 years. So effectively, for many, many thousands, if not millions of immigrants, it is permanent, because if they could just go and be outside the United States for 10 years, they wouldn't necessarily need to legalize their status so much, So that's why it's called permanent, because it's effectively permanent, because so many people can't afford to go spend 10 years abroad in another country. So
Right.
expedited removal followed by an illegal entry, a formal deportation from an immigration judge followed by an illegal entry, or 1 year or more of unlawful presence, leaving the United States, and then an illegal entry. Those are the 3 situations that can trigger the permanent bar. Now, Diego, does the permanent bar apply for someone who is applying for cancellation of removal in the immigration court?
So it does not. And I always try to explain to clients, especially when I'm advising them on what their options are. I often tell them that the permanent bar does not make them ineligible for removal defense, as long as they haven't been out for too long. It's over 90 days if it's at one trip, or 180 days accumulated in 10 years, then they will be eligible to do their cancellation of removal defense, and they should still be able to do that.
So what are the kinds of cases where the permanent bar does apply?
So the permanent bar applies in, mostly what we see is when someone is trying to fix their status through a petition by a family member. So that's the I-130 petition. And so often I think people are given a false sense of security once that petition is approved. And they think, oh, well, the petition's approved. That means that I must have some possibility to fix my status. Otherwise, they wouldn't be doing this. But what they don't realize is that that petition is just looking at the relationship of the petitioner who's asking for you and yourself as the beneficiary. And so it's the visa processing cases that we see that are usually the ones that we look at that unlawful presence in the permanent bar. But it also applies to cases where people are applying for permanent residency right here in the United States. Maybe the individual had a petition that was filed before is April 30th of 2001. And so this law that applies, even though they may have entered illegally, 245I applies, where it allows you to apply for your permanent residency in the United States. But if you have the permanent bar, the special law will not benefit you, and you will not be able to fix your status through a petition by your spouse or your son or daughter, or maybe even an employer, if you have that permanent bar. And so then you would be denied, and then you would be placed in removal proceedings.
Yeah, potentially, or maybe not. But
Yeah.
at the very least, your case will be denied if you're found to be subject to the permanent bar. So I just want to take what you just said and kind of step viewers through a scenario, because it's something that I've seen a number of times in my practice. So let's say someone came to the United States in 1998 or the late 90s or around then, and they had someone file that petition for them, maybe a parent or a brother or sister, or someone filed on behalf of their parents. Maybe it was an aunt or uncle who filed on behalf of their parents, or a grandparent. They had that petition filed for them. And so they were in the United States from like 1998 until maybe 2004, 2005. They had to leave the United States at that point and go back to Mexico. I mean, typically, this is a bar that applies to Mexicans. Okay, that's one of our favorite names for it is the Mexican bar, because it is applicable to so many Mexicans, much more than other countries. Some Central American countries as well, if those people get deported and then enter unlawfully later. But traditionally, because of our border with Mexico and Texas, Mexicans were very accustomed to coming back and forth across the border, working, going home, working, going home. And that had gone on for hundreds of years before this law was passed. So someone comes in late 90s, they have a petition filed for them, then they have to leave for some reason. Maybe there's an emergency, or whatever the situation may be. They go back to Mexico, even for just a couple of weeks, and then they come back without permission. Let's say they get caught, maybe they don't get caught. Regardless, it doesn't matter if you get caught or not. If you made that trip and you have that second unlawful entry after a year of unlawful presence in the United States, that 245I petition that was filed for you before 2001 doesn't help you anymore. You're still barred permanently because of that second unlawful entry after a year of unlawful presence. And so it's so unjust and so severe, because let's say you made that trip in 2002, and you had been here for 4 years and you made that trip in 2002, and now it's 2022, it's 20 years later. Guess what? That bar is still on your case. If you apply for adjustment of status, it's going to be denied. If you leave and go to the consulate for consular processing, let's say you apply for a waiver, you get the waiver approved, your petition's approved, you've gotten your waiver, you think you're all good. Have you ever seen this, Diego?
I have. I've seen it where people apply for the provisional waiver for unlawful presence, but it only forgives the 3-year and the 10-year unlawful presence, but it does not forgive the permanent bar.
Right. Those 3 and 10-year unlawful presence bars are triggered by one unlawful entry or overstaying a visa for at least 6 months or a year. Those are the bars triggered by those things. And if you're an immediate relative and you entered with a visa, in other words, if you're immediate relative of a U.S. citizen, you entered with a visa, it doesn't matter if you overstayed. But if you're married to a lawful permanent resident and you overstayed a visa, then you need a consular process. But if you have a permanent bar and you leave the United States and you go to your consular interview, they're going to tell you that your case is denied because you have the permanent bar, and they'll give you a piece of paper that says you need to wait 10 years outside the United States, and then you can apply for a waiver.
Right.
And I've seen this happen a number of times.
Yeah, and whenever I'm doing those consultations, it's usually the individual says, but I don't understand. If I wasn't able to do it, then why would they approve the petition, or why would they approve the waiver? And I explained that this is the first time that you're going and actually talking to an immigration officer, and they have all that information all together, and that's when they make that judgment call. And I think sometimes it's by mistake, and I think sometimes it's by people that are, not so nice, that take advantage of people that don't understand the system, and they end up embarking on a trip where they find that it's not going to be easy coming back. And
Yeah,
you know, and that unlawful presence can accumulate. So let's say that I come in and I'm here legally for 7 months, and then I leave, and then I come back and I'm here for 7 more months and I leave. If I come back again, that is going to trigger the permanent bar, because I accumulated 14 months of unlawful presence. And then at my departure, that 10, it's not, that would be a 3-year bar still. But then when I come back, permanent bar. And
that's right.
and unfortunately, there just really isn't much that you can do except wait it out. Now, so you and I have represented individuals that have applied for that reentry permit. So it's not a typical waiver. It's a form called an I-212, and we've gotten those granted. And we have actually 2 clients waiting in line so that they can be interviewed and be able to come back. And I've done them before, and they do succeed. And so sometimes people do wait out those 10 years, and it's worth it. I mean, if you have family here, I think it's worth it.
For sure. Yes. If you are in a position to be able to, remain outside the United States for the 10 years, it is possible to then overcome that bar, and that permanent bar with a waiver. It is in fact possible. I've seen it happen. And that's great. The difficulty arises for families where that kind of lengthy stay outside the United States is simply not workable for whatever reason. Maybe part of the family has to remain in the United States. It's just not feasible for anyone or safe for anyone to be outside the United States, for medical purposes, because there isn't enough sufficient family ties in the other country. There could be thousands of different reasons, but if it is possible, then to wait out that bar, and then legalize through a waiver process and a consular process, then that's great. So Diego, how important is it for someone to really get a trustworthy analysis of their unlawful presence and the potential consequences of that on their case before they file for any kind of immigration benefit, especially permanent residency?
Well, it makes all the difference, because they are essentially spending thousands of dollars and spending thousands of hours, trying to earn that money, or when they get out and are unable to come back, lots of time away from your family, and they can be stuck in a really bad situation. And it usually falls as a terrible surprise, because most often when I've spoken to people in that situation, it happened at the consulate. It happened when they were being interviewed, and they had no idea that could happen. Sometimes it's because they decided to self-file, and other times it's because, again, they just didn't have competent help that placed them in that type of situation. And so it's so worth getting the right information so that you can make the right choices.
Yes, definitely. So if you have any doubts, any questions at all about your eligibility and whether the permanent bar may apply to your case, if you have had multiple unlawful entries to the United States over a span of years, If you've ever been removed at the border and have come back without permission, please, please, please reach out to us or any trustworthy, competent immigration lawyer who can take a look at the facts of your case and understand how the law applies in your situation. You can reach us at our website, walkergatesvela.com. On our website, there is a button that you can click to schedule an appointment directly on our calendar, or call our office, and whoever answers that call will be happy to help you get an appointment on our calendar, where we will pick apart the facts of your case and give you a very, very solid answer about whether or not a permanent bar applies in your situation. Please don't let yourself get caught by surprise on that. So anything else, Diego, that we need to add on before we sign off for today?
Just one little point, and it's you don't have to stay those 10 years in your country. You can do it somewhere else. So I've had people say, well, I cannot go back to my country. It's too dangerous. Or I don't want to, I don't know anybody there. And so you don't have to spend those 10 years in Mexico or Honduras or wherever. It's just like, you don't have to go home, but you can't stay here type situation. So as long as you're somewhere else and not in the United States, that time will count towards your ability to come back to the United States.
Yep.
Yeah.
And we will be happy to share with anyone that we meet with how to prove your physical presence in another country. So please contact us if we can help you do that. And thank you so much, Diego, for sharing your knowledge and experience with us. And with that, we'll sign off, and we'll be back in a week with another fascinating lesson in the immigration law. Thank you, Diego.
No problem. I'll see you.
Have a good day.
You too.
All right. Bye-bye.